for the benefit of the general public, I welcome those listening into this from the committee of the Parliamentary Committee on Public Accounts. I beg your pardon, Foreign Affairs and Defence. And before us is Ms. Mary Rakai and Ms. Mary Navurai from Sherani and Company, who will be submitting on the three treaties. For the benefit of the general public, the Madrid Agreement was established in 1891 to provide a mechanism that would allow for a single and inexpensive international trademark registration and to eliminate the need for filing, prosecuting, or maintaining separate registrations in multiple countries. It came into force in 1892. Fiji's intellectual property laws date back to 1933. Fiji is in the process of modernizing its IP laws, hence the three bills endorsed by Cabinet on the 31st of March 2020. They are Trademarks Bill 2020, the Patents Bill 2020, and Designs Bill 2020. The Madrid Protocol was established in 1989. It was created to address perceived defects in the Madrid Agreement and to make the international system of registration of marks more flexible and compatible with the domestic legislation of individual states. The Paris Convention was established in 1883. It was created to provide protection for industrial property, including patents, trademarks, trade names, industrial designs, utility models, service marks, geographical indications, and to repress unfair competition. Honorable members and members of the public, we have before us, as I mentioned earlier, Ms. Mele Rekai and Ms. Mary Navurai of the Sherani and Company. Before you, ladies, is my committee, Honorable Dr. Solik Govind, Deputy Chair, Honorable Selai Andimaitonga, and Honorable Pio Tigundundua, and myself, Alex O'Connor, as your chair. With those words of introduction, madams, a very brief introduction of your good selves, and the floor is yours. Thank you.
Thank you. The Honorable Chairman and Honorable members of the committee, these are submissions that are being made on behalf of Sherani and Company, which is a law firm that's based in Suva and was founded in 1952. The firm has been in existence for about 68 years. It has three partners, namely Mr. Himendra Nagin, seasoned practitioner with over 42 years of experience, and two recent partners, Mr. Ritesh Singh and Ms. Rakai. The firm has two associate lawyers and about 24 support staff. Now, the firm provides various range of legal services to its clients in Fiji, the region, and the world. It has a litigation team, which all the lawyers are a part of, and a very large conveyancing team. Part of the services that we provide to our clients is the provision of trademark or intellectual property to our clients. And these are currently handled by two of our staff, one of which is before the Honorable Chairman and the Honorable members of the committee this morning, Ms. Mary Navurai. Now, for the registration of trademarks, as the Honorable Chair had mentioned, its processes are currently provided under the Trademarks Act 1933. Now, it is largely a paper-based system, not electronic, so everything is done manually. Now, we received the invitation by the Honorable Chairman and the committee to make submissions on the two treaties, and we're very honored to make submissions on the relevance of these three treaties to our work. I'm not going to go into extent of the years these treaties came into existence, as the Honorable Chair had already mentioned them, but I will basically talk very briefly on how they affect our work. Now, the Paris Convention creates international reciprocity and other benefits for trademark registrations. The Madrid Agreement and Protocol facilitates a type of international registration for a mark. Now, the submissions will begin first by talking about the firm's experience with the current Trademarks Act 1933 and its experience on the services that are provided by the Trademarks Registry. Now, these are submissions that are being made on behalf of the firm and may not necessarily reflect the views of other firms and other organizations on this matter. Now, what is our experience with Fiji Trademarks Act 1933? Now, as the Act was adopted in 1933 during the colonial period, it provides for independent registration of goods marks, not service marks in Fiji. And it is something that we adopted from the colonizer. And in Fiji, goods are still classified according to the old British classes. So we currently have 50 classes. Now, priority is not based on filing, but on the existence of the prior application. So it puts the registrar on notice if any of the applications are opposed or there is a possible conflict. Now, as with most registries in Fiji, the Trademarks Registry is one that's not computerized. So our searches are still conducted manually. There's often a lack of resources relative to the volume of the filings. So you will see that if you file to register a trademark in Fiji, it takes several months to several years for a registration application to be completed. Now, for the firm, we've had the oldest trademark application we've had pending is one that we lodged in 2010. We lodged in 2010. It's not 2020, it's almost 10 years, and we still haven't received an update on the application that we've lodged on behalf of our client. And this is despite follow-ups that we've made by way of a letter, by way of follow-ups by Mary physically going to the registry or even calling the registry. So these are some of the experiences that the firm has with the current Trademarks Act and the services of the registry. Now, as the Honorable Chair had submitted or had stated, the Cabinet has already approved the Trademarks Bills, the Patents, and the Designs Bill 2020. But for the purpose of the submissions to the Honorable Committee this morning, we've not been provided these three pieces of proposed legislation. So because we've not been provided these three pieces of proposed legislation, we're not in a position to make submissions on them. So our submissions will be limited to our experiences with the registry and whether there is a need to ratify the two treaties or not. However, at the outset, what we'd like to submit is that the registry could always be empowered with better resources so that it could improve the efficiency of the services that it currently provides to the stakeholders. Now, if you were to go to the Trademark Registry today to lodge a trademark or to make a search, it would be, you'd go to the registry, which is at level 3 at Super Bowl House, you fill a form, and you'd be served by 2 or 3 staff at the registry counter. It generally takes about 30 minutes to an hour to be served. More often than not, when you go and search at the registry, the files are missing, they're not able to assist you, sometimes able to assist you, but more often than not, the files are missing and you'll need to come back later to see if they've located the file. If you need to go to the registry, at the Trademarks Registry, payments is made at level 5 and the registry is made at level 3. If you are to file any application, a counter statement or an opposition, it is filed at level 4. Now, these are some of the issues that we face at the Trademark Registry currently. More often than not, as we as other registries, when we go to the Trademarks Registry, when Mary goes for that matter, sometimes when she goes, there is no running water, there is no electricity, and the registry closes for the day. Now, these are some of the disruptions to the services. Now, when these services are disrupted, it also affects the delivery, the timeline delivery that we have to our clients. So if the registry is closed, obviously we're not able to conduct our searches and we're not able to provide timely deliveries to the clients that come to the firm for the provision of legal services. Furthermore, from 2000 onwards, there has been no tribunal. So if a trademark is contested, what we find in our experience is that there's an opposition, there's a counter statement that's filed, and there is no outcome by the Trademark Registry. So for the experience of the firm, we have a matter that was pending in 2018. It was opposed, we advertised, it was opposed, and we filed a opposition. There was a counter statement filed. All the relevant documents are before the registry. However, from 2018 to now, we still haven't received an update from the registry on the status of our client's trademark. So what that means is we are unable to advise our clients on the status of their registration or of their trademark, and they tend to then question us on the the efficiency of the services of the Trademark Registry. These are some of the challenges that we face. The other challenge that we face is that the Act itself is quite outdated. We adopted it during the colonial period, which is 1933. It's been 87 years since then, and we're still using the Act. There is a need to revise the legislation. While we are happy that Cabinet has approved the 3 bills, it would be important if we were to be provided the 2 bills so that we could have a look at whether the concerns that we have been improved in those proposed 3 pieces of legislation. Now, the Honorable Chair and the Honorable members of the committee, obviously you are only interested in what is our stand on the treaties, whether we propose that Fiji is in a position to ratify the treaties or not. Now, the firm has been around for about 68 years. 68 years, Sherani and Company has been operating in Suva. For that 68 number of years, we've served many clients from Fiji, clients from the region, and clients from the world. We have not once utilized the 2 proposed treaties, or the 3 proposed treaties, that is the Paris Convention, the Madrid Agreement, and the Madrid Protocol. Now, because we've not utilized this, or used these 3 treaties, we're not very familiar with the treaties, apart from the fact that we've read about them. And because we're not familiar with them, our submissions is basically based on what we've read about the treaties. In terms of experience, we've not used them. So our humble submissions to the Honorable Chairman and the Honorable members of the committee is that our submissions will basically be narrowed down to what we've read about the 3 proposed treaties. Now, I will move on to the 3 treaties. As the Honorable Chairman had submitted, the 3 treaties are supposed to make foreign registration of trademarks much easier. Now, the Paris Convention, if you were to compare the Paris Convention with the Madrid Agreement and the Madrid Protocol, you'll see that the scope of the Paris Convention is very wide. It is not limited to only trademarks. It covers other forms of industrial property, as the Honorable Chair had mentioned. So it covers copyrights, it covers patents, it also covers trademarks. Now, one of the advantages of using the Paris Convention is that it provides you with the same protection if you were from that country. So an example is if you are a US-based business and you want to register a trademark in France, you would be accorded the same protection that a French corporation would be given, subject to certain restrictions, making sure that the trademark doesn't go against morality and public order, for that matter. The other advantage of the Paris Convention is that it includes priority rights. So what that means is if you file in one of the member countries, that application will be taken from the date you file. It can be extended as well. Now, the only downside to using the Paris Convention is that you need to register country by country. So as I talk about the other 2 pieces of treaties, which is the Madrid Protocol and the Madrid Agreement, you'll then see what is the advantage of using the other 2 agreements as opposed to the Paris Convention. Now, the Madrid Protocol and Madrid Agreement is very different from the Paris Convention because it has really streamlined the international registration of foreign trademarks, meaning you can file a single international trademark and it could be potentially extended to many foreign countries. Now, for any of the customers or clients that we serve, the key word is cost cutting. You want to reduce your costs. So if you're going to have to register only once, that means cost is greatly reduced, as opposed to the Paris Convention where you had to register country by country. So the Madrid Protocol and Agreement, in comparison to the Paris Convention, is cost efficient. It is because you only register once and you extend. However, the downside to using, or the disadvantage of using the Madrid Agreement and Protocol is that if there is a cancellation in any of the home countries, then it automatically will also cancel the subsequent international registration. So that's the downside to using the Madrid Protocol and Agreement. Now, those are perhaps the very brief advantages and disadvantages of between the two. Now, I'm coming to the important part of my submissions, which is what would Fiji need to implement the two treaties? In order for Fiji to implement the two treaties, apart from looking at which of the three is better, we would have to make sure that we have the 6 requirements in place. And the first requirement is ensuring that we have compatible local legislation, ensuring that we have an institutional organization, ensuring that we have staff that are properly trained to use the two treaties, whichever it is, the Paris Convention or the Madrid Agreement and Protocol, and their registration system, ensuring that we have the operational procedures for handling international applications, ensuring that we have agreements in place for the treaties and their respective bodies. So if it's going to be the Madrid Agreement, ensuring that we have the proper agreements with WIPO. And the 6th is making sure that the national office has an online system for registration. Now, as we have already submitted earlier, Honorable Chairman and Honorable members of the committee, we have been informed that Cabinet has approved the trademarks designs bill 2020, but we've not and patents bill, but we've not been provided copies of this bill. So we respectfully would need to submit that. Out of the 6 requirements that Fiji would need in order to ratify the two treaties, we don't have any of the 6 at the moment. And until we have those 6 requirements, we're not in a position to ratify the 3 treaties, so to speak, today. But what do we have today? What do we have this morning? What we have this morning is we have the Trademarks Act 1933. We have a Trademarks Registry at Suvavo House. We have trademark staff that are employed there. We have a trademark system that's in place. We have trademark experience, the good and the bad, from 1933 to date. That's what we have. Now, our respectful submissions is that while we don't have the 6 requirements to implement or ratify the 2 treaties or the 3 treaties, we have with us current legislation, when we have a team that's already in place. Why don't we empower them? Why don't we revise our laws? Why don't we improve our systems? Why don't we better train our staff? Improve the resources of the Trademarks Registry, which is, improving their system from manual-based or paper-based to a computerized system, and improving our delivery time frames based on our past experience. When we improve what we currently have, then realistically, we're in a better position to consider whether we are then in a position to ratify the proposed treaties. Now, Honorable Chairman and honorable members of the committee, our respectful submissions this morning from the firm is that we already have a system in place. Can we improve that? Because when we improve the efficiency of the services of the Trademark Registry, it then reflects well on the registry. It reflects well on the laws that we have, and it reflects well on the country. And when the services or the efficiency is improved, then it also would flow to the stakeholders. Then we, like Sherani and Company, would be able to, give timely advice to our client on the registration process of our trademarks, and not have trademarks that have been pending for 10 years, trademarks that have been pending for 2 years. And, if that is improved, the system is improved, it also is a better reflection of all of us, including the stakeholders that utilize the services of the registry. So our respectful submission, and I'm coming to the end of my submission, is today we're not in a position to ratify the 2 treaties. That is our humble submissions. Maybe we will one day, but certainly not today. Those are our submissions, the Honorable Chair and the Honorable members of the committee, unless you have any questions to ask of us this morning, sorry.
Thank you, Mr. Wakai, for that very informative submission. And I'm very much surprised to hear in today's advanced technology that what you say is we still have not been able to digitize the system. And certainly the other thing is not having been able to centralize all the officers, like you say, they're all in different levels of Superboy House. But I would imagine that they would have been all centralized now. Apart from that, honorable members, you have any sterling questions for the two ladies? Thank you.
Chair, if I may.
Yeah. Yes.
Okay.
Go ahead, Honorable Pio.
Yeah, Chair. Thank you, Ms. Rakai and Ms. Nabroi. I understand that Sherani, in terms of intellectual property, deals primarily with trademarks. Is that correct?
Yes.
Okay.
That is correct.
Okay. I'm curious because the intention of the intention of the Madrid Protocol in this matter for Fiji, and the argument that is being made to the committee is that it makes it easier for foreign companies to register here, as you have explained. Now, I just want to know, as far as Sherani is concerned, how many trademarks from Fiji do you register overseas, say in the region, Australia, New Zealand? Do you register any trademarks at all?
Thank you, Honorable Mr. Tikandundu, Honorable Chair and Honorable members of the committee. In respect to the question, most of the clients that we have, we're dealing with a local registration of trademarks here in Fiji. We don't register outside. If it's outside of the country, they utilize the services of law firms from those respective countries. Yes. Am I correct, ma'am? Yes.
Okay, so which means that your firm does not handle any registration of a trademark from Fiji with your counterparts, for instance, in Auckland or in Sydney or wherever for that matter. And you would not have any indication of that.
At the moment, no, sir. We only have international clients or regional clients. Sorry, sir. Yeah. Honorable Chairman and honorable members of the committee, in respect to that question, at the moment, we don't register outside of the country. We receive instructions to register locally in Fiji.
What about the other way around? What about clients from abroad registering trademarks, patents here through Sherani?
Yes. We do receive instructions. Those are the instructions we received.
Is that a significant number?
We have a range of clients, Honorable Chairman and Honorable members of the committee. We have a range of clients. So in terms of numbers, we maybe receive instructions a few a month.
Okay. All right. But okay. Now for those ones, can you give me a relative time? Because you said the registry process here, and we've been told by other firms, the Fiji IP office seems to be of the opinion that they are ready to have it now. They're the only ones saying that. I do not agree with that personally, due to my own understanding of what they have. And you're saying here today also, the businesses of trademark is covered in 3 floors of the same building. So because things are so manual right now, how long does it take? I mean, currently, in the cases that you have and have lodged with the Trademark Office and have yet to be approved, how long does it take for these applications to be processed? You have pending ones that are beyond 12 months there already?
Honorable Chairman and honorable members of the committee, Mary has just indicated to me that it takes several months. Now, in our submissions, we've stated that a general application to lodge a trademark takes between several months to several years. Now, we've given 2 examples. The oldest trademark application that we have pending is one that we lodged in 2010. We've not received an update. In another matter, we lodged an application in 2018. It was opposed. All the relevant counter statements and notice of opposition have already been filed. We've not received a response to date. Exactly. So 2010 and 2018. So about 2 years and 10 years it's pending. But for applications that do go through, it takes several months. So Mary has indicated it takes about 3 to 6 months. If it's it's a process, if it's a trademark that easily goes through 3 to 6 months to several years.
Yeah, I understand you read a little bit of the Madrid Protocol, because it is significant. If you're talking about a 10 years delay, the Madrid Protocol allows only up to 12 months, if not 18 months, before any application from abroad becomes automatically approved in the receiving state. Are you aware of that?
That is correct. That is why in coming towards the conclusion, we looked at whether Fiji is in a position to ratify the the three treaties. We listed out the 6 requirements, and we said that out of the 6 requirements, we have not fulfilled any of the 6 requirements. So that is why our conclusion to the Honorable Chairman and the Honorable members of the committee is that we're not in a position today to ratify the treaties at all. Apart from the fact that we have a manual system, there's 6 requirements that need to be fulfilled. We don't have any of the 6 today, including a compatible domestic legislation. We don't have that either.
Thank you, Mr. Kai and Ms. Naburai. Thank you, Chair.
Thank you. Thank you, Honorable Mr. Tikondondua.
Honorable members, any further question? Honorable Andi Selai, Honorable Dr. Salik.
Yes, Honorable Chair. Honorable Chair, may I just ask?
Yeah, go ahead, Honorable.
If under this Madrid Protocol, once we ratify, then businesses can register from their own countries. So I just want to know, in terms of revenue, what sort of revenue figures you may not be able to get from overseas companies who are registering through you now. Is this significant or not so significant?
Honorable Chairman and honorable members of the committee, I ask if the honorable member could repeat his question. I couldn't quite get the question. If he could just...
Honorable Chair, what I said was that once we ratify the Madrid Convention,
yes, sir,
the businesses can register in Fiji through their own registration system in their own countries. So they may not utilize the services of your firm. Right now, they have to apply to your firm to register in Fiji. But under Madrid system, they can register in their own country and be registered in Fiji. So in terms of revenue loss, what are you thinking in terms of revenue loss to your company?
Honorable Chairman and honorable members of the committee, I think that is a very, very good question. How does that affect the business? How does that affect a firm like ours? Now, the Madrid Protocol, one of the advantages of the Madrid Protocol is that a single international trademark registration can be extended to its members. So what that means is that countries that clients that before used to come to the firm, once Fiji ratifies the Madrid Agreement and Protocol, what that means is they don't need to come to Sherani and Company. That's the long and short of it. They don't need to come to us. They just apply directly to their home country and they can ask for the registration to be extended to the member countries. So there will be a reduction of legal services. There'll be a reduction of clients that come to us because there's no need for them to come to us. That is one of the advantages of the Madrid Protocol and Agreement. It streamlines the international processes. So in a way, it would reduce the number of clients that the firm would currently have. So that is a good point in terms of how it would affect the business or the stakeholders. And I mean, we're one of the many firms that's based in Suva.
I have no more, Chair.
Does that answer your question, Honorable Dr. Salik?
Yeah, thanks. But I just wanted to know,
Honorable members,
is it significant revenue loss in terms of millions or in terms of thousands of dollars?
In terms of, thank you, Honorable Chair and Honorable members of the committee. In terms of dollar figures, how significant it is? You said whether it's going to be in millions or it's going to be in thousands. In order to answer that question, I would have to put some context. Now, Sherani and Company has been around for 68 years. We do trademarks. We do provide intellectual property services, but that's not a large part of our business as compared to Mandulis, that has a very large intellectual property division, as compared to Siwatimba and Sloan, that has a very large intellectual property business. It's one of the services that we provide. It's not the main service that we provide. So in terms of business, it's going to affect us in terms of thousands of dollars. But I cannot say the same for my other law firms or the other law firms that deal primarily in this business. Their services would it would affect their businesses a little bit more than it would affect us. So I think the question will need to put the context in terms of how big is the intellectual property division for the different firms or the different stakeholders. For us, it's just one of the many services that we provide our client. So obviously it's going to affect us in terms of thousands if we were to rectify the two treaties today.
Yeah. Thank you very much. I don't have any more questions.
Thank you, honorable members. Time has caught up again. I take this opportunity to thank Mrs. Rakai and Mr. Navurai for their submission this morning. If you have any departing remarks, the floor is yours. Thanks, ma'am.
Thank you. Honorable members and you want to say something? Honorable Chairman and honorable members of the committee, we're very grateful to be given this opportunity to make submissions, and we do hope when the bills have been, ready, that we would be given an opportunity to make submissions again so that we can see whether the proposed legislations are indeed compatible. Thank you very much for this opportunity.
Thank you.
Thank you. Thank you.
Thank you, and you have yourselves a blessed day, Nakam.
Thank you, Honorable Chair.